Welcome दोस्तों. We welcome you on LLA exclusive member webinar number 11. So double digit का मामला आगे बढ़ता जा रहा है and we are taking on various topics related to compliances and labor laws. And today I'll be taking a topic which is really important and really complex. There are probably very few experts in India who can take topics like this and discuss it with you and discuss it with authority. And we are fortunate to have a guest who can deliver on this topic and teach you about this topic. So today we are taking the topic of PF international worker. So the compliances of international workers are challenging for two reasons. Number one, the rules itself are somewhat convoluted. The rules itself are somewhat not clear, as well as authority force those rules in very unconventional, different ways. Number second, these cases are obviously rare. So if you see 100 Indian workers, probably one you can see of international worker. So there are not many experts in India who can talk about this topic with authority and share the details with authority. So today we have a speaker who has immense experience in this field. We have a speaker who has 23 years of experience in various compliances, assessments, audits. He is currently HR head and senior advisor at HR Vidyalaya Corporate Service LLP. He has done numerous assessments, webinars, talks, presentations, trainings with various big companies such as ITC, BAIL, and you name it, various other companies. He is also expert in POSH, Social Security Benefit, CLRA, PF, ESI, and have done various corporate trainings. So I'm very fortunate to have authority on this subject of PF international worker, and I welcome to this live stream Mr. Anandan Subramanian. Welcome, sir.
Hi, good evening.
Good evening, sir. How are you today?
Yeah, I'm fine. Little excited now. The introduction is okay.
So, sir, you probably deserve much more words, but this is what I could summarize in probably 1 minute. So, sir, wanted to start with some basic idea or basic concept, like why this international worker or of PF compliances are complex. What is the reason it is complex?
Basically, only two reasons. The establishment is not able to identify who's the international worker. Identifying the international worker itself is so difficult, a challenging one.
Okay, so there's some, because the mic is moving, the disturbance is coming. Yeah.
Okay. Now is it okay?
Yeah. You can also okay. You can keep the mic in front also if it's okay.
Okay.
Okay. Yeah. Got it.
So the main challenge is identifying the employee, whether he or she is a international worker or not. That is the most challengeable task every employer is facing. Number one. Number two, what is the wages? On which wages the contribution has to be deducted and remitted. That is the most difficult one. The third one, as everyone knows, on separation, whether the employee member can get the accumulations, whether PF or pension, how he will get things like that. So these are all the major challenges. Two, during the person gets appointment in an Indian organization which is covered under PF EPF MP Act, and the third sensitive one is separation. These are all the difficult things.
Perfect, sir. So I guess by end of this video, there will be a lot of clarity on all these three major challenges. So the format will be, as all the audience already know, so there will be a presentation, and today we have try to keep it very interactive. So what we will do is, after 4 or 5 slides, we will take a small Q&A break, and I'll take up the questions from the comments. There are few questions which from the members I have already forwarded to sir as well. Those questions also we will cover towards end of this webinar. So you can ask the question as and when they are coming related to the slide. And if there are any general question over the topic, we can take up towards the end of the webinar. Sir, is it okay if we use this format?
Yeah, fine, perfectly fine. So I also will be enjoying the session. Unlike lecturing the session, it will be interactive. Once in 4 or 5 slides, you can stop me so that
Right, sir.
I'll answer the question. I'll pick up the answer, a question and answer.
Perfect, sir. So now you can start the presentation, and I'll take a back seat, and I'll also start learning from you.
Okay, thank you. Okay, ladies and gentlemen, thank you for your time. First of all, this is a very subjective matter where we are going to discuss under the biggest social security organization, EPF and MP Act, and most probably we expect something will happen by start of next year. This is going to move into code on social security. The code has already been notified, and we expect regulation and scheme. It is not going to be the rules. It is going to be the regulation and scheme for PF and DSA. We expect something until such time, or even after this is going to move into code on social security. Most of the provisions of the act is going to remain same, except for very few. That one is related to the international worker, which I will tell during this presentation. Okay, so first one, major disclaimer. Definitely, yes, this is merely an educative session. We are not opinionating on anything. So whatever I am going to tell, it is out of our experience. It is from the provisions of the Act and whatever the industry practice. That's all. More than that, we are not liable for anything. So please check with or your corporate legal team or your legal team or any other person from your organization. This is the biggest disclaimer. As mentioned, you can raise your questions throughout the session. We will take up the questions, and I'll try to answer it immediately or definitely by end of this session. Okay, today the learning objective is going to be the awareness, definitely educative in purpose, understanding what employer has to do and what are the benefits of IW. This is the major 3 areas. Generally, what we need to know about the international worker under EPF and MP Act. So agenda is going to be like definitions, various definitions. I'm not going to detail of EPF in particular. I'm going to talk only about specific to the international workers and the contribution for international workers.
Sir, sorry to interrupt. Is it possible for you to just remove the mic itself? And if you are using laptop, then you should get the voice. Like, are you doing it on laptop? Not no, just not able to hear you. Anirudh, I guess वो cam settings में change करना पड़ेगा ना?
There's an unmute option. वहाँ पे he has to unmute himself.
Okay, sir. There is an unmute option on your on the Chrome window. You will see a unmute option from your on your profile
Screen on.
Yes. Yeah.
At the bottom, there's an unmute option.
Yeah, is it okay now?
Yes, sir. Perfect. It is perfect. Yes, sir. We can start.
Okay. So the agenda is going to be the definitions and the contribution for the international worker. What is the actual contribution, and we will be touching upon the Honorable Supreme Court's judgment dated February 28, 2019 also. And what is SSA, the employees of SSA, and non-SSA, what is non-SSA, excluded employees, difference between employees and excluded employees, those who are applicable but excluded. Employee benefits and withdrawals, the most sensitive part. Duties of employer and many FAQs I have listed on my own. I have received a few from the participant. That also I have listed. Irrespective of that, you can also raise through the session. Okay, first of all, this is the most important definition we need to know before going into the details of international worker. So under EPF and the MP Act, there are different types of workers. So please be very, very careful in understanding the worker type. Okay, domestic worker, basically an Indian, holds an Indian passport, or an Indian national not holding an Indian passport. Very simple, that's all. Domestic worker. Nepali or Bhutanese. Nationals from Nepal, nationals from Bhutan. These two are a separate category. Singapore citizens and nationals who are coming into India for temporary workers. They are a different type of workers. I'll explain what is the difference between all these. And then the fourth one is international worker, meaning a foreign national or an Indian who's having more than the Indian passport. For example, an Indian who's having Indian passport as well as US passport or as well as UK passport, things like that, or only a foreign passport. International worker from non-SSA country. SSA country, I'll explain. SSA country without COC. SSA country, it is a bilateral agreement agreed between India and the host country. It is an instrument to protect the interest of the workers. So there are, as of now, it is 18 different countries to whom India has signed SSA. So a worker who is coming from a SSA country, for example, Japan or Germany or France, who is coming without a COC, certificate of coverage. COC is nothing but certificate of birth. That is the fourth category. Fifth category, international worker who is from a non-SSA country. Non-SSA countries, nothing but the countries to whom India has not signed the bilateral agreement. The major example is US, UK, Sri Lanka, very close to us, Sri Lanka, Pakistan, we have not signed. Sixth category, international worker from SSA country. For example, the same fourth category, but these people, for example, Japan or Korea or German or France, they did not come with a certificate of coverage. They pay social security over there, but they come to India to work, but they did not carry certificate of coverage. They are called the sixth type of workers. And then domestic worker engaged in SSA country. Domestic worker, for example, I am a domestic worker, Indian, having an Indian passport, or Indian do not have an Indian passport, or in this case, I have an Indian passport. I am going to social security agreed country on employment. Example, again same, I am going to Japan or Germany or France on employment. I will be on the rolls of Indian company here. I'll be on a short term, in the sense 1 year or 2 year, 3 year, maybe 5 years also. I can go to that country. In such case, I will be called as an international worker. This is the seventh type of worker. And then the most important, where most of the establishment fail to identify the individuals, and many establishments are later paying heavy damage and interest. That is category called OCI, Overseas Citizen of India. These are also another type of workers. We will be seeing what is the difference, what is the definition of each category in the later slides. So first of all, how to identify who is an international worker among the type of workers I had shown in the previous slide. Okay, so if your employee is having a passport other than Indian passport, so this slide is all about a person who is having other than Indian passport except the first one. The first one, if your employee who is on your establishment role holding only Indian passport are going to work for a company in social security agreement signed country, so until such time he works in that social security country, until he works. If it is on a business visa, medical visa, tourist visa, it is not required. So he will be treated as an international worker for that period. Okay. So on his return after 1 year or 2 years, if he comes back, he will be treated as a domestic worker. Initially, even these people were treated as an international worker, and there was an industry representation. Later, he also was called as a domestic worker on a return. So they will be going with a certificate of coverage from EPFO in India, and they submit it later. I'll show you the process also. Once they come back, they surrender the certificate of coverage. Immediately, they will be treated as a domestic worker. That is the number one. These people will be called as an international worker for the period they perform duty in the social security agreed country as an employee. The second one, if your employee who is going to be on your role, who came from a SSA country, but does not have a certificate of coverage. So here they come, they did not, for some reason, they did not obtain, and they did not come with a certificate of coverage. They will be treated as an international worker. Third one, employee who is going to be on your role, who came from a non-SSA country. As I told, it is from USA or UK or any other country who are not listed in the SSA signed country. They will be called as an international worker. So why I differentiated SSA and non-SSA, that also we will see in the later slides. The fourth one, if your employee is having a overseas citizen of India, whether he is from SSA country or non-SSA country, OCA card holder, usually these people just like that walk in. They will not come with a certificate of coverage because they hold Indian name, they hold OCI. There is no requirement of any employment visa. So just like that, they come into India. So they usually do not come with COC. They are called international worker. So as we have seen in the previous slide, exclusions. Here the exclusions, there are two different exclusions. One is Nepalese and Bhutanese. They are considered as domestic worker, like an Indian worker. Okay, that is number one. They are excluded. They are not international worker, but they are considered as a domestic worker. Whereas a Singapore citizen or a national who comes to an India on a temporary work assignment, they are excluded. There is no requirement to consider PF at all. So there is a difference in the exclusion. Please be very careful. In Nepal or Bhutanese, they are covered as a domestic worker. Whereas for Singapore citizen, it is only for the temporary period. If they come to India and they should not be a permanent resident in India, then they will be excluded from payment of PF altogether. So there is a treaty signed between India and Nepal in 1950 and India and Bhutan in 2007, through which they are considered as a domestic worker. So with Singapore, there is a bilateral agreement between India and Singapore, Comprehensive Economic Cooperation Agreement, CECA, where permanent residents who are not permanent residents, Singapore nationals, who comes to India for a temporary job, they will be excluded. So this is the definition for excluded country nationals. Okay, so I am consolidating the previous two slides. So who is a domestic worker? So Indian nationals having Indian passport and do not have Indian passport or any other passport, but Indians. So they are considered as a domestic worker. Citizens of Nepal, domestic worker. Citizens of Bhutan, domestic worker. I think there is no confusion over here. International worker, foreign nationals, persons having passport other than Indian, who are from non-SSA country, UK, US or any other country, they are international worker. Persons having passport other than Indian, but they are from SSA country, but they do not come with the COC. They are considered as an international worker. OCI category, OCI status, all people are called international workers. And also the other category of international worker is Indians who are traveling for employment to other SSA country are called international workers. Excluded, we have seen the first definition is for the domestic worker. Excluded employee, domestic worker is a person who's a first timer joining an organization covered under PF Act whose wages are more than the PF ceiling wages currently, which is 15,000. A person who is a first timer, here the first timer definition is I as a person who had worked in a previous organization, but I had withdrawn both PF and pension. If I join another organization, I will also be called as an excluded employee. So there are two different differences. I am the first time I'm joining an PF covered establishment. I have not worked and my basic wages is more than 15,000. I am an excluded employee as a domestic worker, and I am an Indian. I am a domestic worker. I had worked in a previous establishment, but I had withdrawn both PF as well as pension, and I am again joining an organization where my basic wages are more than the PF ceiling wages, which is currently more than 15,000. I am also excluded employee. If required, I can desist from paying a PF, covered as a PF member. But if employee and the employer agree, they can be a PF member. That is excluded employee definition for domestic worker. Excluded employee, international worker. Singapore, we have seen. So Singapore residents, they are excluded. Second is those who are coming from an SSA country, coming with a certificate of coverage. Okay. So I will see this slide, overseas citizen of India. After this, maybe I can take some questions. So OCI, I'll please see that red sentence. PIO was already abolished. It is that status is not there in India. Person of Indian origin is not there. OCI is now there. So the person who's holding OCI status, sometime they'll be having an Indian name. They'll have an Indian face also. No, like there are our own people where their parents or forefathers migrated to other country. They got their residency, and these people will be having other passports. They can get, that is what I have listed here. So who can get OCI status? Which are all foreign nationals can get OCI status. So these OCI status people can come into India for employment without any employment visa. So here they will not have a visa. They will be having an Indian name. They will be having an Indian face. So when they apply for any job here, we just like that recruit them, and we don't see initially during the selection whether the person is holding any other passport other than Indian passport. So later, there is a big problem. Some audit happens, or somewhere these OCI people will be, in the sense, get caught that they are treated as an international worker, and the employer has to pay heavy fine, damage and interest, only because the difference between the contribution of domestic worker and the international worker is a domestic worker, it is at least 12% on the restricted PF wages, that PF ceiling wages, that is 15,000 currently, or the actual basic. But for an international worker, it is on the gross. Okay, so if a person OCI who comes to an Indian establishment and joins as a domestic worker, later a year or two, if he was or she was found as an international worker, identified an international worker, then they have to pay the difference. And the difference and the damage and interest, the maximum is 37%. So paying that big money, and also both the employee and the employer contribution, that is more disturbing for any establishment. And number two, if there is any such arrear payment has to be paid, the difference, the employer cannot ask the past money of the employee contribution from the employee. So there is a specific provision in the Act. So from employee, you can only deduct previous month's PF contribution. You cannot deduct unless otherwise there is an increment or any promotion for the previous year from the retrospective date. Otherwise, these kind of areas cannot be deducted from employee. So it will be a heavy burden on the employer. So during selection itself, every employer has to go into big, this kind of collecting all these details. And also down south, I have seen with my experience, many establishments are engaging Sri Lankans who are international workers. They have to be very, very careful. So later they realize that it is on the gross and paying the difference and taking the burden of paying that difference on the employer is very difficult. So employers should be very, very careful. Those who are managing payroll or managing HR, managing recruitment, have to be very, very careful. Okay, before going to this slide, I can take any questions are there related to the 4 slides what we have discussed so far.
Okay, sir, thank you so much. We will take couple of questions, and before that, I'll just, because of there are few members who are not so much comfortable with English, I'll just summarize that part in Hindi as well.
Please.
तो अभी तक सर ने क्या कवर किया है, तो मेन बात आपको जो ध्यान रखनी है, सबसे पहले इंटरनेशनल वर्कर होता कौन है. तो इंटरनेशनल वर्कर वो वर्कर्स हैं जो बाहर से आके हमारे साथ काम कर रहे हैं. सर, जस्ट फॉर क्लैरिटी, कैन समवन होल्ड 2 passports, Indian and say American?
Then they will be considered as an international worker. Okay. That's why I said more than Indian passport also considered as an international worker.
Got it. So ध्यान रखिए दोस्तों, तो जो भी लोग हैं जो फॉरेन में काम कर रहे हैं, फॉरेन मतलब जिनके पास फॉरेन पासपोर्ट है, वो इंटरनेशनल वर्कर कराते हैं, लेकिन उसमें कुछ एक्सेप्शंस है. फॉर एग्जांपल 2 एक्सेप्शन जो हमारे भारत के 2 बहुत अच्छे दोस्त हैं, नेपाल और भूटान. वहां के वर्कर फॉर ऑल प्रैक्टिकल पर्पसेस इंडियन वर्कर्स ही कहलाएंगे. हाँ, हो सकता है उनका आधार नहीं होगा, और आपने ऑप्शन भी देखा होगा पीएफ में कि बिना आधार के भी आप नेपालीज एम्प्लॉय को ऐड कर सकते हैं. तो वो वाला सीन है. बाकी नेपालीज और भूटानीज इंडियन सिटीजन चलेंगे. सेकंड इसमें एक्सेप्शन आ जाता है सिंगापुर के सिटीजन का. वो अगर शॉर्ट टर्म असाइनमेंट के लिए इंडिया में आ रहे हैं तो वो भी इंटरनेशनल वर्कर नहीं कहलाएंगे. थर्ड इसके अंदर आ जाता है कुछ हमारी कंट्रीज है जिनके साथ हमारा सोशल सिक्योरिटी एग्रीमेंट है, उनके लिए भी रूल्स काफी रिलैक्सेशन है, और वो अपनी कंट्री से कवरेज का एक लेटर लेके आ सकते हैं, और उनको यहां पर फिर कवरेज की जरूरत नहीं पड़ेगी. बाकी और सारी कंट्रीज के लिए जो भी एम्प्लॉयज हमारे यहाँ काम करने आते हैं वो इंटरनेशनल वर्कर, इंटरनेशनल सिटीजन कहलाते हैं. तो गॉट इट. तो ये अभी तक की समरी है. अब मैं सर, देयर इज अ क्वेश्चन, आई विल शो इट ऑन स्क्रीन आल्सो. जस्ट अ मिनट. Can you share the list of SSA countries?
Yeah, I am sharing. In the following slides, I am sharing.
Okay. So right now, sir, there's only this question only, so we can continue further.
Okay. I'll move on. So, what is the pay for international worker? Pay in the sense the wages on what the PF contribution is to be deducted. Okay. It is gross wages excluding HRA and overtime allowance paid. HRA, I am very specific on this. I have a great experience of people structuring for the international worker in a different way. For example, a person who is in Delhi, Mumbai, Chennai and Kolkata, usually it should be for 50% of the basic being drawn. Or maybe any other city, it is 40%. But I have seen many establishments where do not know whether it is consciously done or unconsciously done. The basic pay will be 1 lakh, but HRA will be 2 lakhs, just to avoid PF. But this will definitely be identified sometime. I'll tell you one thing here. Please don't have only that PF authorities will come for inspection, it will be identified, they will come once in 2 years or 3 years, then we can manage the situation, things like that. Don't do that. Right now, nowadays, the scenario has changed in India. I'll tell you why. Because there are so many assessments and audits are happening across the organization. How? For example, a company is getting some investment, a company is getting merged, a company is getting a joint venture, or the company is going to do a product or service. I'm getting a new project. and the other company who is going to give a project, they are not just like that going to give that to the countries from Europe and US. They are just like that, not giving any project or any just like that companies. They will do an audit, assessment, external assessment will happen. In such situation, these are all easily identifiable, and the management will be in a big trouble. They may not get a project altogether because of simple challenges which has been not been handled properly. Okay, so HRA, be very careful. That's why I am telling during recruitment, identify first of all, that is I have listed that, identify the individual, whether the person is an Indian worker, domestic worker, or an international worker, whoever it is. What is the problem? You are getting so many details from that individual. Why don't you ask whether the person is holding a passport? Passport, which passport? If he's a nationality, what is nationality? That is no wrong. So you can definitely ask. So that question is more important. The second one is fix appropriate HRA for the international workers. So some international workers, they are paying as a consultancy fee, or they pay as an allowance a gross amount. It's very easy for them to deduct PF. But some companies, what they do is they have a structured salary. While doing the structure, be very careful in fixing the HRA. Overtime allowance, which is not paid across the board to all employees, in particular, that is excluded. So HRA and overtime, it is excluded. Other than this, anything is attracted for PF. It is 12% on the gross. So there is no restriction like 15,000 PF ceiling wages, something like that. So it is on the gross. On what contribution is to be made? This is the biggest no doubt every other company is having. It is a total salary payable on account of employment, employee employed for wages by establishment covered. For example, I as an establishment in India engage a person. He will be joining here on an employment visa. He visits and he will be taking up a position, but he'll be doing from here for some other organization in the host country or different country. For that also he will be paid. So here, that's what here we very clearly mentioned. Any salary which is paid to that person for his job performance in India. So if he is doing something, any business income coming out of his host nation, so that is a different one. It's nation, his own country, if he's getting any income, that is a different one. But it is out of his job performance here, then it will attract PF. And in India, even for responsibility outside India also. That's what I said. So I work here. I have a responsible for APAC region. So I do something over there where the salary is being paid from there, from here, something like that. So altogether, put together, I have to pay PF. That is what is very clearly mentioned. If you don't do that, and maybe this month or next 6 months, you may escape. But if some audit assessment happens, if it is from PF, you have to pay with the divergent interest. If you get caught by the assessment agency of external agents, the damage on the brand is something different. So you may not get the project, or maybe a difficulty and challenge in getting your projects also, or a merger or an investment, any financial assistance you are looking for, things like that. Okay. Okay, what the Honorable Supreme Court earlier, people were having doubts like this is a different allowance, that is a different allowance. Why I need to cover? Because as it is, the international worker are getting more than 3 lakhs, 5 lakhs. Apart from that, they are getting many other allowances. Why should I pay? Because it is the employer is burdened with so much of money. That's what they had telling. After the Supreme Court order, Honorable Supreme Court on February 2019 reiterated with 5 different similar judgment cases. The judgment is where a payment is universally, necessarily, and ordinarily paid to all employees across the board, it constitutes basic wages. So what cannot be considered as wages, the second 3 points were not variable in nature, which is linked to perform extra work and were paid across board to all employees in particular category. So if a person is performing a overtime, and if the person is because he is doing an extra job for that, and it is very clearly stated that he'll be doing that. If he is doing that extra work, he'll be paid extra. In such situation, such allowances are excluded from attraction of PF contribution. So petitioner were unable to prove the allowances were variable. So in that 5 cases, all the petitioners could not able to justify what is the allowances payable, whether it is allowances towards the regular job they are doing, or any other special job, overtime or something like that, performing extra job they are doing. So that was a difficulty they could not able to prove, because I tell no, I wanted to quote one single case in that 5 cases. It was around 21 years old. So proving what is payable in the initial years, it is very difficult for the employer. So they were paying everything. Special allowances and other similar allowances which form part of an employee's wages are considered basic wages, are thus subject to PF contribution. Special incentive production bonuses which have a direct link with the employee's output fall outside the scope of basic wages. So it is to be very, very clear. So considering the PF for an international worker on his earnings, an establishment have to be very careful on these two. Then they can consider PF. This is a snapshot of the Honorable Supreme Court judgment. The recent one, the final one on the allowances. This is what the SSA signed countries list. There are 18 countries. I think if somebody wants to take a screenshot also, they can take. These are all the 18 countries. If somebody comes from these 18 countries, or an Indian worker goes and work in this country, they are excluded from paying double coverage. Double coverage in the sense, I go to Denmark, so I will be international worker and I will be paying social security only in India. There is no requirement for me to pay social security coverage in Denmark. If there is no SSA agreement, then I have to pay here and I have to pay in Denmark also. And also, maybe if I am not going to pay from here, I have to pay in Denmark. If I work for 2 or 3 years, how to get back that money? Those are very challengeful. But if it is an SSA signed countries, if you go and work, there are some benefits that we will discuss in the later slides. Essentials of Social Security Service Agreement. Social Service Agreement. Labor mobility between countries. This has enhanced, from 1995 after globalization. Everything has enhanced. Many people started moving in. Industrialization has also enhanced. People started moving from countries to country, and everybody, employers felt that when I am sending a person from my company, they have to take care of their social security in India as well as the social security there. Or maybe if I import some machineries, or I require a consultant to come from a foreign country, he has to be paying no social security over there, and when he comes here, I have to take care. So these kind of problems were there, and government of India intervened, and they started negotiating, and the social security agreement were signed periodically. Up till now, it is 18 countries it has been signed, where if I go to SSA signed countries, there is no double coverage. I can only pay here, or a person who comes from German, they can pay only there. There is no need for them to pay social security in India. Why? Because I'll tell you, this is more favorable to India, because I think the social security contribution in the other countries are very, very high. when compared to India. In India, it is very low, but in other countries, it is very high. But for the international worker who are in India, it is very high because it is on the gross. So the SSA is to protect interests of migrant Indian worker, basically to our Indian worker, the contribution exemption in the host country, and exportability of the benefits. Now we are going to see what is exportability. There are three different types of benefits: detachment, portability, totalization. We will see the definition. A detached worker is an individual who is posted in their employer by their employer to work in another country on their roles for a limited period, where worker is exempted from contribution in the country where he or she is going to perform duty. For example, a person travels from France to India, they will be contributing over there. So they will be contributing there. So there is no requirement for them to contribute in India for the period they are working in India. They will come with a detachment certificate, that is nothing but the certificate of coverage issued by the immigration department over there, or maybe labor department over there in their country. If they come with a certificate, then they are considered as an excluded worker. This is a detachment benefit, so they are not required to pay benefit, PF benefit here, contribution here. The second one is benefits from the other country can be availed by beneficiaries in the home country. For example, the same person who came to India, he worked here for 2 years. So for social security, that is nothing but the pension. So they can consider this 2 years what they performed in India for their continuation of services in France. Similarly, the person who worked in India travels to Japan or travels to Germany or travels to Korea. Usually it happens because from people go for an employment of these countries, and the period 3 years or 5 years they work, when they come here, they can consider that 5 years as a continuation of services for calculation of pension. So that is portability. They can consider this, and also maybe for one more example, I have given an example in the next slide also. We will see that examples for this definition. It refers to the total period of contributory service rendered by the PF member and benefits arising out of the same. We will see the example here. That is totalization. Detachment, we have seen many times, we have discussed the same thing. The points I have given underneath the red line, that's an example. Mr. Abe comes from with the COC from Japan to work in India for 2 years and continue to contribute in Japan. So as he comes from Japan and he is holding a COC, there is no requirement for him to contribute PF in India. Peter, Indian, goes to Canada from India and work for a year and will be covered in India as an international worker. As soon as he comes back, he will be treated as a domestic worker. This 1 year period where he was working in Canada will be considered for his service in social security, under social security here. So detachment, that is detachment. So that person comes with the COC from Japan, Peter goes with the COC from India. So they are detached workers. The portability, Simon, who got superannuated in India, employee pension scheme, he had worked in India and Germany also as well. So he now wanted to settle in India where he can get to transfer the services of period. So here there is no money involved. They will consider only the period as a service. Services of the period he performed in Germany into Indian bank account and vice versa, in the sense that period will be considered as a service. So for example, he had performed only 10 years here, so 2 years in Germany. That 2 years also will be considered for his calculation of pension. So vice versa. So the person wants to go to Germany and settle. So the period what he had performed in India will be carried over in German. He will get a better benefit because he will be adding more years he has performed in India. That is portability. Totalization. If any person from India goes to SSA country without COC. So for some reason, a person from here goes to South Africa, or maybe we'll take the same example, German or Japan. For some reason, COC was he could not able to get. So he goes there and work there, and they have to continue to contribute there. So not continue, they have to contribute because they don't have a COC. They have to contribute over there. So by the time, because he was in the roles of India, he might or he might not have. Usually they will be contributing here also. There is a double coverage. They have to pay. The employer who is sending this person has to pay here and they have to cover there because TOC is not there. Upon return to India, she will be treated as an international worker and be entitled for totalization of such contribution period. So later they can consider both a period, because there also they had work, here also they had work. They can consider the total period for the purpose of social security. It is only restricted to the contributory period of service under the respective social security program. Okay, what is the process? Indian employee traveling to SSA country for employment. So as I said, I'll take the same example. Peter travels to SSA country for employment. She will be working in SSA country for a fixed period, 1 year, 2 years, 3 years, or 5 years. To avoid paying social security in SSA country, she has to obtain COC in India. They have to apply. If he is already covered in PF, he will be applied online. Maybe now in 3-4 working days, they are getting the COC certificate of coverage. They can obtain COC and then they can submit that COC in whichever country, SSA country, where he or she is going to work, and they will be excluded from payment of social security over there. But they will be treated as an international worker in India. So from the day he is joining the other organization, the other office in SSA country, he will be treated as an international worker, and EPF will be on gross wages. When he returns to India, can surrender COC and change the status from IW2 international worker to domestic worker, and then contribution gets reversed. It will be restricted to 15,000, which some companies are practicing, or it will be on the actual basic wages. So there will be a difference once he comes back to India. The next process, person from SSA country, from German, national or citizen from German, coming on an employment visa to India to work in a PF covered establishment. So here this person could not able to get the detachment certificate. That is certificate of coverage. So he will be treated as an international worker. Whether he is paying social security over there or not, he has to be considered as an international worker here, and PF is to be paid, and it is on the gross. So all Form 11 details have to be collected with him, and he has to be considered as an international worker in the portal itself, while the member details are uploaded in the PF portal. Currently, there is no requirement of Aadhaar, but in Code on Social Security, this is what I was now telling in the initial slides. There is a small change in Social Security Code. Even Aadhaar is even required for foreigners. So RS coming into India has to obtain Aadhaar for the purpose of PF. I think for purpose of PF, maternity, ESI, anything and everything, Aadhaar is required now. When Code on Social Security is going to be there, Aadhaar is compulsory, mandatory for anything and everything. Deduct PF contribution on gross, excluding HRA and overtime or any other wages, which is particularly related to his own skills. If paid in foreign currency, every time convert into equivalent Indian rupees. For example, somebody is paid only on Japanese yen. Okay, so every month he'll be paid on Japanese yen. So it cannot be fixed at 10,000 into, you cannot count into 30 or something like that. So you have to verify what is the forex rate I think it is listed in the SBI bank. Every month it will be listed. So you have to convert that money into Indian rupees. On that Indian rupees, 12% has to be paid. It will vary, definitely vary. As it is varying every day. So it will vary. So if it's not in Indian rupees, you have to do this, follow this. Any monetary payments paid abroad for the job, we have seen this. So any payment for the job performance in India will also be considered for PF contribution. Now, this is a different one. Person from non-SSA country, we'll take a right example, US or UK, coming on an employment visa. I am repeatedly telling this. This a person who is coming on an employment visa only will be covered for PF. A person who comes on a business visa or comes on a tourist visa and joins an organization, it is, I think, crime. I cannot tell correctly, but that person who comes on a tourist cannot work in India. Business visa, they cannot earn any money. So I think something not legal. So a person comes on an employment visa to India to work in a PF covered establishment. He will be treated as an international worker. So he cannot get a COC because there is no signed SSA agreement signed between India and that country. Upload Form 11 details, same, everything, whatever has been done in the previous slide. So everything is same. What is the difference between the previous one and this one? While separation, we will discuss. The another category, a person from SSA country who comes with a detachment certificate, that is a certificate of coverage. They apply over there, they come here, they produce the passport, they produce the visa, they produce this certificate also, get a Form 11 details, attach a copy of detachment certificate, and then don't deduct any PF. They are called excluded employee. No PF has to be deducted. For OCI, so OR is an OCI, maybe from SSA or non-SSA. As I told, they usually do not come with an employment visa. In such situation, it is very difficult for them to apply a certificate of coverage in the host country, and they will just like that walk into India for an employment. So they will be treated as an international worker. The process is same. They will be treated as an international worker. Whatever process we have discussed for non-SSA country or SSA country, that is there. Because they are not getting detachment certificate, they will be considered as an international worker. Okay, so now we have seen the definitions of the types of worker. I'll take some questions if at all we have received, and then I'll go out to withdrawals.
Okay, sir. Let's. I'll just summarize first, and then we'll take couple of questions.
Please.
Okay. So दोस्तों देखिए, अभी हो सकता है आपको ये टॉपिक थोड़ा कॉम्प्लेक्स लग रहा हो, बट कॉम्प्लेक्स प्रोबेबली इसलिए है क्योंकि ये एक्चुअली है थोड़ा कॉम्प्लेक्स. तो आपको इसमें ऐसे समझना होगा कि जो भी इंटरनेशनल वर्कर्स हैं उनको हम लोग दो कैटेगरी में बांट रहे हैं. दो कैटेगरी में ये समझिए कि ज्यादातर वर्कर्स, ज्यादातर मतलब अभी वर्ल्ड में करीब 200 से ज्यादा कंट्रीज है, तो उसमें से ज्यादातर कंट्रीज जो है वो कवर्ड है, वो नॉर्मल सिनेरियो में कवर्ड है, और उनमें से 18 कंट्रीज के साथ हमारा एक सोशल सिक्योरिटी का एग्रीमेंट भी है. सोशल सिक्योरिटी एग्रीमेंट जिन कंट्रीज के साथ है उनको काफी सारे रिलैक्सेशन दिए गए. अब ये सोशल सिक्योरिटी एग्रीमेंट आखिर किया क्यों गया है? ये किया इसलिए गया है कि मान लीजिए कोई फॉरेन का बंदा है, वो इंडिया में आता है, अब वो अपनी कंट्री में उसका कुछ पीएफ टाइप चल रहा होगा, मान लो यूएस का सिटीजन है, उसका अपनी कंट्री में पीएफ टाइप चल रहा होगा और 2-3 साल यहाँ पे आके काम किया, तो यहाँ पे भी उसका पीएफ जमा हो गया. अब हर जगह जैसे अपने यहाँ पीएफ में रेस्ट्रिक्शन है कि पेंशन 10 साल के बाद बनती है, सारी चीजें हैं, वैसे ही वहां पे भी रेस्ट्रिक्शन होगा. तो उसका दोनों जगह पैसा फंस गया और बेनिफिट उसका यूएस में वापस जब जाएगा तो बेनिफिट कम मिलेगा. तो इसलिए गवर्नमेंट सबके साथ नेगोशिएट करके सोशल सिक्योरिटी एग्रीमेंट्स बना रही है. अब ये ज्यादा कंट्रीज के साथ क्यों नहीं, 18 के साथ ही क्यों है? जहां पे हमारे पास लेवरेज पावर है नेगोशिएट करने की, वहां पे ही हम कर पा रहे हैं. अब इंडिया में कुछ कंट्रीज है जहां से इंडिया से बहुत ज्यादा वर्कर्स जाते हैं और वहां से हार्डली कोई आता है, जैसे यूएसए हो गया, ब्रिटेन हो गया, सऊदी अरेब, दुबई, अबू धाबी, ये सारी चीज हो गई, जहां पे इंडिया से तो बहुत ज्यादा वर्कर्स गए हुए एक्सपेट्रिएट्स, लेकिन वहां से बहुत कम आए हुए. तो इन कंट्रीज के साथ अभी नेगोशिएशन चल रहा है बट हुआ नहीं है. इन कंट्रीज के साथ हो जाएगा तो इंडियन को बहुत ज्यादा फायदा हो सकता है. बट एज ऑफ नाउ 18 कंट्रीज के साथ है. जिनके साथ है वो अगर अपनी कंट्री से डिटैचमेंट का सर्टिफिकेट लेके आएंगे और उसे पीएफ पोर्टल पर अपलोड करेंगे तो फिर उनको यहाँ पर इंडिया में कंट्रीब्यूशन नहीं करना पड़ेगा। चलिए, अब मैंने कुछ क्वेश्चंस लिखे हैं और आपके भी अगर क्वेश्चन हो तो मुझे कमेंट्स में बताइएगा। सर, फर्स्ट क्वेश्चन, you said that appropriate HRA. What is this definition of appropriate HRA?
Okay, I'll tell you. That is not there. No, few things we always have to refer the other legislation. That's what I said. No, appropriate HRA. HRA is excluded. The exemption we have to refer the Income Tax Act, where metro cities it is 50% of your basic, and other cities it is 40%. So, for example, that's what many times the honorable courts also told that you cannot just like that. They used many words. We want to avoid the PF. You cannot use other terms. That's why I said you have to have an appropriate HRA, either 50% of the basic wages as in the compensation structure, or 40%. So that's why I quoted an example of few establishment. They'll be paying 1 lakh as basic, but 2 lakhs, whereas it is only 50,000 or 40,000 should be HR as per the Income Tax Act. But they will give a compensation structure of 2 lakhs, so that 2 lakhs will be excluded from PF. So I'll tell you here, Income Tax Act also very clearly states that if a person is paid HRA, the exemption is only 50% or 40%. More than that will be taxable. So the employers are taking advantage of that also. For example, then the same stretch, if I tell that a person is having a basic 1 lakh and his HRA is 2 lakhs, for the income tax purpose, if I am in Pune, so it will be 1 lakh and 40,000 will be exempted. Balance 1,60,000 will be taxable. But here, if I have the same structure, there is no need for the employer to pay PF on that 2 lakhs. So that is what this is not mentioned anywhere, but during inspections in the PF department, they very easily catch this, and they levy damage and interest on the difference in the HR. That's why I'm repeatedly using the appropriate HRA. Otherwise, it will be very difficult for any employer to face the PF inspections.
Got it, sir. The other question is, this is, for example, we take CAs. So CA can work in our firm, but they are not covered under PF. So in the same manner, many companies hire foreign nationals for some specific kind of work or some audit or some consulting assignment. Are they also covered as international workers? Those who are covered as a consultant, not an employee.
So okay, so whether the nomenclature doesn't matter for PF. That's why I very clearly stated the visa, employment visa. I think I have taken a question also from a participant. The answer is there in the last slide. So it is a visa. It doesn't matter whether you are a consultant, you are this profession or that profession. If you are coming into India with an employment visa, you will be considered for PF. And then you have to check whether what type of worker. That is a different story. But if you are coming with an employment visa, you are a worker.
Okay, sir. Very basic question. This is something I guess many people will have doubt on. You said that foreigners must also have Aadhaar. Just a basic question. Can foreigner have Aadhaar and can they have PAN card?
See, PAN is compulsory for everyone. PAN everyone can take, but Aadhaar is not mandatory for foreigners so far. For example, so far, if a person is coming with an employment visa, with that visa, they will be appointed in an organization. With that, they can apply for PAN. PAN is must, because to open a bank account to get their salary, it is must. So PAN they can get. But Aadhaar is not mandatory, and many foreigners do not have Aadhaar. Many foreigners do not have, and it is not a requirement currently in PF. If you upload the Form 11 details in the PF portal of the employer, if you tell that, if you check the checkbox stating that he is an international worker, it will skip the Aadhaar details page. and it will move on to the PAN or any other detail. So it will not ask for Aadhaar. So for foreigners, currently Aadhaar is not required.
Okay, sir. So last question, I guess this, if you have covered this in future slides, we can skip this also. So the question has two parts. The 12% contribution by the employer, in which head does it go? Is it the same as any domestic worker, 1250 towards pension and then remaining towards PF? And is employer also mandated to match the contribution till the gross wages, or he can contribute till the ceiling wage?
Okay. This is a big question, and I'll take the question because this is very, very important. I have not covered here because it is a very big subject, and also it is pending sub judice in the Honorable Supreme Court. I'll tell you. A person, whether Indian or foreigner, who is the first timer who joins an organization, a PF covered organization after September 1st, 2014, there is, and if the basic wages is more than 15,000. For example, whether I am a foreigner or an Indian joining an organization, my basic wages is 20,000 or more. There is no mandatory requirement for PF for the domestic worker. For international worker, it is mandatory. I am talking about the PF. Second part, as per the amendment in September 2014, for both domestic as well as international worker, there is no requirement for EPS contribution. So 12% on that 20,000 will go to the PF employee. 12% on the employer contribution also will go to PF. There is no EPS diversion for those employees who had joined after 2014. This is applicable for both the Indian domestic worker or international worker. But after this amendment, there was a court case went to Honorable Kerala High Court, and this entire the pension, this area was struck down, and the EPFO went for an appeal in Honorable Supreme Court. They upheld the Honorable Kerala High Court judgment, and then again the EPFO was gone for a review appeal. It is listed for many times, but I think due to COVID, it was not came for the discussion. Hopefully this week or the following week, I think it is again listed. The review is going to come. If the Honorable Supreme Court is going to upheld the same its own judgment, and Kerala High Court judgment, then everyone has to contribute to pension also from 2014. But it is a big job. That's why I think EPF is regularly going for a review appeal. But this is the last time. Year after, they cannot go for a review appeal. If it is failed before Honorable Supreme Court judgment, then for whomever the EPS is not contributed after 2014, they have to work in reverse, taking everything from PF and then paying to pension. That they have to do. That is number one. I am taking the question from the participant. If a person was joined before 2014, for them pension is 8.33 on employer contribution, restricted to earlier it was 541, not 1250, 541. 1250 is from September 2014 only, that is 8.33 on 15,000. Right. For international worker who had joined earlier 2014, if he still works, it is 8.33% on the gross, not restricted to the PF ceiling wages, will directly go to the pension. So for example, an international worker who joined in an Indian organization in 2012 is still working, where his basic wages is 10 lakhs. So an 8.33% on 10 lakhs employer contribution will directly go to the pension. There is no restriction for that international worker. I think this is the answer for that. But the pension, hopefully after the Supreme Court judgment, the status quo goes, if it is goes in favor of EPFO, or otherwise there will be a big change in contribution towards pension. I think every employer, PF office, everybody will have a big challenge in recalculating everything.
So I guess if I've understood correctly, the employer is also bound to contribute on gross wage. Employee is
See,
the
no,
bound.
no. See, I'll tell you. For international worker, if employee is paying 12% on 10 lakhs, employer is also bound to pay 12% on 10 lakhs, where 80.33% without restriction will go to pension. If that
Okay.
international worker was engaged before 2014.
Got it, sir. Got it, sir. Okay, we can move ahead and we will
Okay.
take further questions.
So now we will be moving to withdrawals, the most sensitive area. Everybody is finding very difficult, and I'll tell you what are all the difficulties throughout. So an international worker from a SSA country who has contributed means okay, without a COC, he has contributed or she has contributed. They can withdraw EPF on completion of assignment. Very, very simple. I'll tell you the very simple exercise. For example, if I'll take an example again, a person from Japan is working in my organization, is going to leave on October 31st. Okay. So what it is decided. So what I can do is before 6 days of this month. So within October 6th or maybe on the 6th, I can pay contribution for that international worker now itself on a separate challan for October month. So I can pay now, considering the person is going to be on my rolls for 31 days and the last working day is going to be October 31st. So I will pay subjectively. I will pay 6th or 7th of October. I am paying contribution for that person. Okay. After paying the contribution, I will file the IW return selectively for that person, separate. Third, I will complete all KYC updation, approvals, everything. That is number one. PAN, bank details, any other details, date of birth, any nomination, e-nomination details. E-nomination is must, mandatory right now, even for the international worker. It may not ask for other details, but otherwise nomination details for them also required. So they have to be completed and then put the date of leaving October 31st, and the online application can be submitted immediately after these processes are over, maybe 7th or 8th or 9th. The online composite claim form can be submitted. But apart from that, some RPFC will be asking for some physical document. Maybe you can scan it and send it, or maybe you can courier it, or maybe send it through speed post, or you can give it to the front desk in the PF office. I will tell you what are the list usually people are asking. Sometimes they ask more also, but otherwise, what is the selective document they will be asking? Then they have to submit, and if you follow up on the 31st day or before the first week of November, this person can get his or her accumulation in the PF. So this process is there in PF office, but nobody is exercising this process. This can be done. We have done it, and we have got it on the last working day or within 3-4 working days of the separation of that particular international worker. This is happening. So people can try out this, provided every other detail, KYC detail, everything is pakka, IW returns are filed, there is no issue for that international worker. That is withdrawal for international worker. And this is only, I'm talking only about PF. Pension part, if that person has contributed to pension, it will be paid on reciprocity, in the sense, in Japan, if what is the agreement between India and Japan? In Japan, if somebody is working there, what that government is giving, similarly this government also will give, or otherwise they will tell that okay, you no, that is what we have seen. No, you can consider the period what you have performed in India for social security coverage in your country. So these 2 years they will not give you the pension. The 2 years they will consider for the social security period. So they will get a good pension. Add these 2 years also. As I told you, pension is a service. Pension is a service. Even for the domestic worker, it is more than 10 years. It is service. It is not money. So they will consider these 2 years in Japan. So what has been agreed between India and that particular country, that will be done. So some countries they will pay pension also. For many countries they will be paying only PF. So this is the withdrawal number 1 for IW from a SSA country. IW from a non-SSA country, a person who's a foreigner. I'll take example US, because I am taking, why I am taking US or UK. Many OCI status people are also coming from US or UK. They will come to India, they work here, and if they go back, OCI or a foreigner, US national, they can withdraw PF only upon attaining after 58 years of attaining their age, any time after that or immediately after that. And in special circumstances, I will explain what are the special circumstances in the later slides. Pension usually is not settled, definitely, because there is no agreement at all between that country. Usually pension is not settled. As one single explanation beyond this, pension will not be settled. I will discuss that in the later slide. So withdrawal modes, for example, whether if I am here, I'll tell you the withdrawal mode. I very specific. Be very no, be attentive more than what you are having no attention to the past slides. Bank account of a foreigner will be non-operative after the person exits India. For example, when they go back and the visa is stamped, cancelled, and it becomes non-operative. But they can retain the bank account, Indian bank account, for next 6 months, only to receive monies from the government, like PF or anything, any balance money or anything. But if my colleague is leaving, who's a German or a Japanese, is leaving, so if he is having a bank account, I cannot deposit any money to that account after the person leaves as an employee. But a government can put money, so they can keep that in bank account until 6 months time. By the time they can receive money, they can take money from there. So whichever mode maybe they can apply and take, or they can transfer from Indian account to their account, or to any bank of Tokyo, something like that, whatever bank, HSBC, Citibank, anything they can take. So they can retain the bank account up to 6 months only to receive money from government. That is rule number 1. Or if it is not possible, they have closed the account. It is, I think I have received a question from a participant whether they can open an account again. It is not possible. It is not allowed. No Indian banks will allow you to open an Indian account in India if you are not in India for some purposes. Maybe for employment purposes, you will not be allowed. So you have to apply through an employer. So an employer will apply everything. He will receive. And there is a question from the participant also, like, how to get through an employer. The employer has to give a direction to a request to PF office, and direction for employer to get that money. Upon that, employer will give undertaking stating that that money will be taken from the RPFC and then give it to the individual employee who has joined with their organization. If that organization has already closed, that organization is not there, in such situation the person has to reach out to the Indian consulate or Indian embassy or Ministry of External Affairs, whatever there in their country. Through them they can apply and then get. There will be different kind of a process there. They have to only approach the diplomatic organization, Indian Ministry of External Affairs, consulate or embassy in or Indian High Commission in their country, then they have to get. So these are all the 3 different areas. IW is overseas bank account. They can have, provided Reserve Bank of India approves. But I don't think this has happened recently. There is an option still open, but it will be open to the Reserve Bank to approve. I think there are different kind of forms, form A2, something like that is there, I think. So that is a difficult area. So if the person is having a bank account in India or through employer, it will be very easy to follow up and get that money. The documents for withdrawal, if it is online, composite claim form. It is there in the system itself. There is no need to do anything. Just fill up and get a OTP and apply. Or offline, you have to take a printout, sign it, and attest passport copy. If you have different passport, multiple passport copies, visa pages. Sometimes they renew visa. All visa pages have to be submitted. Sometimes if you do online also, these documents are being asked again, so you have to physically submit it. Copy of registration certificate upon their arrival in India within 14 days, or maybe I think they will register and they'll get the RC. PAN copy, mandatory, definitely they have to give. Bank details or cancelled check. They are asking for a cancelled check with the name of the person. And photo they are asking. Few RPFCs are insisting on photo of that person. Nomination details, if it is not done online, it has to be e-nominated, mandatory. Otherwise, nominee details they are asking. And other than that, what I had already told, IW returns should be immediately completed, and payment has to be done. Date of leaving has to be done. Everything has to be done correctly. So pension shall be dispersed in the manner as per the terms. We have discussed this also. Premature, this documents for withdrawal is for both SSA country and non-SSA country. So non-SSA country, it will happen only after 58 years of the age of the person who had worked here. So premature withdrawal for employees from non-SSA country, permanent total incapacity of the person, maybe as an example again we am taking from a US citizen or a UK citizen, permanent and total incapacity, it should be duly certified with the medical officer of the establishment. If the establishment do not have such medical officer, any prescribed medical officer or any other certified surgeon certified by the EPFO, where money has to be paid by the individual only. So they have to certify that the person is having a permanent and total incapacity. In such situation, even the PF member of a non-SSA country can apply and withdraw money immediately. No pension, only PF. A member suffering from tuberculosis or cancer or leprosy, again medical certificate only can talk. Unfortunate death, definitely yes, and nominee can get immediately. For under these special circumstances, the person from non-SSA country can withdraw PF. Otherwise, they have to wait. If a person was aged 30 comes to India from US and worked only for 2 years, 32 years, and he has to wait for another 26 years to withdraw as per the current bilateral agreement, which is status. If it is signed next year, then they can withdraw immediately. Okay, duties of employer. Identification of international worker, that's what I said. During the person who joins interview itself, selection itself, they have to identify whether the person is international worker or not. Identify the individual and deduct 12% right to deduction on the gross and remit it before due date. Why I am repeatedly telling this one is, if you pay ESI or PF on due date, you can book that as an expense. If you miss the due date, you cannot book as the expense. So take this as a separate subject. If you pay PF and ESI before 15, that much money can be booked as an expense in your books of accounts. If you fail, then that cannot be booked. So that's why this will be taken out only during assessments. So PF is not bothered. The employer is bothered only kind of an assessment or at the end of the year when balance sheet is being done, things like that. So ensure that it is paid due date, and also if it is going to be on gross, that is a big money, so you cannot book as an account. Employer will be at loss. File monthly online return IW1, same 15th date is the last day. Don't delay. You may get a notice from the employer, the EPFO, if you are non-compliant. Indian worker going abroad, ensure apply certificate of coverage through online before employee leaves from India to that country, deployed in SSA country. Consider deduction on gross here in India because he will be considered an international worker. On return, surrender the COC, apply for change in the status in the portal, and then consider as a domestic worker. Maybe if your company is paying on 15,000, now change into 8,800 per month or on actual basis. So continued duties of employer, IW getting separated, IW from SSA country. That's what I said. Apply for by 6th day of such month, IW can get his withdrawal claim settled by day of separation. We have discussed this. So anything we have discussed, everything that process, the same process. IW getting separated from a non-SSA country. Remittance can be included in the regular monthly challan because there is no point. No, he is not going to be settled immediately. So he can be included in the regular monthly challan. But IW returns has to be correctly done within that month. Ensure the date of leaving is updated in the portal. Many employers miss this. They forget that that employer, and sometimes maybe at his age of 58, who is there going to attend this and put the date of leaving. So by end of the month you complete this. Okay, this is what is the format of international worker monthly return filed. I have taken up one screenshot. The first one will be the Indians, who will be first part will be the Indians who are every month you have to do this. The Indians who have gone to SSA country, those details were captured. Their personal details, their UN details, what is the salary for them, the passport details, visa details, everything will be captured. That will be displayed in that return. The second part is any foreigner for whom PF deduction is happening from SSA country who is without COC or from a non-SSA country who will definitely will not have a COC. Those details will be captured. This is the format. So this has to be done before 15th every month online. There is no offline. Earlier it was offline. Now it is online. So now I am coming to FAQ. I have prepared a few FAQ. After this, I will discuss on few what I had received already. After that, I will go for the balance FAQs. Post finance bill of budget 2020. Can we still recommend HRA for international workers? This is the most biggest question coming up after April. Old tax regime is good for IWs who are remitting PF in India because HRA is excluded. If they choose new tax regime, it is on the whole, even HRA is considered for tax. So bear it in mind. Those foreigners who are not covered can choose. If HRA is not there, they can go for new tax regime. Otherwise, they can stick to old tax regime. Hope they will correlate workings for regimes and conclude. So better they have to work both. So what I have given is a suggestion. PF settlements for IWs from non-SSA countries who are working in exempted establishment, whether the person is working in an exempted or non-exempted process, everything is same. They have to follow everything. If a US citizen is working in an organization which is covered under trust, they cannot just like that from that trust, they cannot just like that settle that money. It is a non-compliance. They cannot settle. Salary not paid in India, contract in home country, and only allowances are paid in India. How to compute PF? Many times I have received these questions during my previous establishments. Any compensation paid to an international worker in India or in home country for his or employment in EPF covered establishment shall needs to be considered. So if the person is performing from India, even the money what he receives or she receives there will be considered for PF contribution. If salary is paid in home country, allowances are paid in India, then such sum of both shall be considered. Any per diem allowance as agreed by both employee and employer in the offer letter is exempted. So that is not a wage. Okay. How non-SSA member who is 40 now goes back to his home country can claim PF at his age of 58 years? We have discussed this. They can go to the Ministry of External Affairs, maybe in UK they can go to Assistant High Commissioner or High Commissioner, or in US they can go to Embassy or Consulate.
How EDLI is calculated for international worker? It is same as a domestic worker. Same, it is coverage up to 15,000. Anyway, it is not going to be paid by the employee. Employer is only going to pay the same 2.5 lakhs to 6 lakhs coverage will be there. Pension amount deducted from IWs of SSA and non-SSA country. We have discussed. This is what I wanted to tell. IW from SSA country, before completing pensionable service, that is 10 years, on the date of exit or attaining 58 years of age, whichever is earlier, he shall be entitled to benefit as may be prescribed. So what is the agreement between the SSA country and India? Whatever is in mentioned, whether they can withdraw that money or this can be portable, totalized to their service there in the home country, that will be done as a reciprocal basis. If it is IW from a non-SSA country, before completing pensionable service on the date of exit or attaining 58 years of age, whichever is earlier, his or her entitlement to withdrawal benefit under paragraph 14 shall be on the principle of reciprocity. Even here it was principle of reciprocity. If the other government is going to give withdrawal of the sum, it is not pension, withdrawal of that sum, then we will also give. The other country is not going to give, he will not get or she will not get. That they can check only with the PF office. For any clarification, an employer has to reach out to the regional PF office, regional PF commissioner. What determines the social security compliance of a foreigner? The purpose of visit, as I told you, it is employment visa. Our Indian branch in SSA country is engaging a local person. So our company is having a branch in Germany. They are engaging a local person. Will he be covered as an international worker? No. Those local persons shall be covered under social security legislation of such country where he is recruited and engaged, because they do not belong to Indian payroll also. One of our Indian employees transferred to SSA country and will be directly engaged by the local employer. So we only give the manpower and the person is going to be directly engaged by the that company, but for 2 years or 3 years. But he will not be in our role, but we will support them in consultation, things like that. He will also not be covered under Indian PF. He will be covered under the local legislation only. Okay, these are all the queries what I had received from today. An international worker coming to India, what is the minimum salary to be paid? You have to refer to the Ministry of Home Affairs. What is the eligibility criteria to apply for employment visa? It is 25,000 US dollar, except ethnic cooks, language translator, not English translator, language translating teachers. I think I left a word. Language teachers translating foreign language to English, or you can consider as a language teachers, not English teachers. Staff working in embassy or consulate. Except these three categories, any person who comes to India should be getting a minimum annual income of US dollar 25,000. So you can consider divided by 12, that will be the gross. If you compute HRA, take out that HRA, balance will be determined for PF. Very simple calculation you can do. In case of a foreign national holding OCI, coming back to India for a job, what is the minimum salary? Now, as I very clearly told, they are not going to come with an employment visa. Nobody can monitor. There is no strict rules. There is no mandatory condition for fixing a salary for an OCI. An international worker from non-SSA country leaves India before completing 58 years of age. Then, for PF and pension withdrawal, which can be done only after attaining 58 years of age, does he have to visit India again, or will he be allowed open Indian bank account? We have discussed this. Such IW can apply EPF from their home country through Indian mission, Indian consulate, or through their employer in India. If they are still there in India, they can apply to their employer. Once the person leaves India, bank account can operate only up to 6 months. We have discussed this. What is the interval period for submitting life certificate so that pension remains continue? Can something done be Now pension life certificate is only online. They are not accepting offline. It is once a year. In case of death of IW employee, does pension remain continue for family members like the rule which we has for Indian employee? Yes. Only for those who comes from an SSA country. For other countries, it is on again and again. I am telling for their country, for the countries to whom India has not signed, it is only on reciprocity condition. What is the procedure and rule for PF withdrawal through employer bank account? We have discussed. Request the EPFO or RPFC with a request letter. A member has to write. Employer agrees to it and in a separate condition. Attach appropriate documents. You can check with the regional PF office what are all the documents they require for that particular settlement. And then if you do that, you will get the money to the employer and the employer has to pay back. Maybe an acknowledgement after payment to the PF member, they have to resubmit it to the PF office. So, any other questions?
Yes, sir. Thank you so much, sir. First of all, I would, on behalf of every participant, would like to thank you because you have covered this very, very complex topic very comprehensively. And I guess everyone of our members and even me, we are all concluding that let's not hire international worker because the compliances are so difficult.
No, don't do that. That is what most of the employers are doing after this maternity was enhanced at 26 weeks. Don't do that. It is some legislation comes for the betterment of individuals. Don't do that.
Okay.
And also, I regret. I am very sorry. I don't know Hindi. I could not able to serve the few the participant. I am very sorry for that.
No problem, sir. No problem. I guess there are various questions, but all are, I guess, already covered in the last slide. These are all similar questions which are being covered. There is a even the HRA. There is a question related to HRA which we have already covered. So I guess questions are all covered. If I am requesting participant, if they have any other questions, then they can ask in comments. Otherwise, we will conclude this and have with the concluding remarks.
No, anytime, maybe even if you receive it, maybe consolidate and send it to me. I will reply to it, and you can upload the answers also while you are uploading it.
Right, sir. Right, sir. So let me just conclude the last part of this, and sir, if I am wrong, you can correct me. So as you have seen, the international worker compliances are you need to file international worker return separately again. एंड इसके लिए आपको क्या करना है, आपको पीएफ की साइट पे पूरा प्रोसेस ऑनलाइन है, अलग से आपको रिटर्न फाइल करना है. अगर ये मेंबर्स एसएसए कंट्रीज से आ रहे हैं तो जॉब छोड़ने के बाद अपने पैसे निकालने की चांस है उनके पास. अगेन उसमें देखना पड़ेगा किस तरह से एग्रीमेंट हुआ है. अगर वो नॉन एसएसए कंट्रीज के साथ आ रहे हैं तो उनको पैसा 58 साल के बाद ही मिलेगा. और अगेन द प्रोसेस इज डिफिकल्ट. बैंक अकाउंट कैसे करना है, मिनिस्ट्री ऑफ एक्सटर्नल अफेयर्स तक जाना है, बहुत सारी चीजें हैं. मे बी अब सुषमा स्वराज जी नहीं है, लेकिन उनको ट्वीट करके शायद आपका काम हो सकता था. So the entire process is very, very complex. At least it seems now, but sir is doing since many years, and I guess sir has seen almost all the things. Sir has also shown कि हाँ पैसा भी मिल जाता है, सारी चीजें हो जाती है और even faster भी पैसा मिल जाता है. तो हाँ, करने से ये चीजें आएगी. और जिस तरह से मैटरनिटी बेनिफिट का थोड़े टाइम तक रहा था कि जब एक्ट आया था तो कई लोगों ने हायरिंग उस तरह से अपनी अलाइन करी कि लेट्स नॉट हायर फीमेल्स, बट दैट्स नॉट द राइट अप्रोच. सिमिलरली इस केस में भी आपको कंप्लायंसेस का फेमिलियर होना पड़ेगा. सर, वन स्मॉल क्वेश्चन इज कमिंग इन केस ऑफ apprentice, like some trainee or some intern is coming.
Apprentice are not covered under PF.
But these apprentices are not like covered under the apprentice portal. The international apprentice or international trainee, which generally comes in schools or some swimming clubs or something like this, are they covered under PF?
No. See, that's what again. Then you have to go to refer the Minister of Home Affairs on what status they are coming. If they are coming under employment visa and you are going to pay from employer, yes, and they will not get a visa if it is less than $25,000.
Got it, sir.
No. You will be coming only as an education visa or a medical visa or a tourist visa. Those people cannot be engaged in an establishment. That is punishable offense.
Got it, sir. yes, I guess that concludes everything. And I really thank Anandan sir for taking out time and giving so much knowledge about international worker to all our audience. I thank you from bottom of our heart and from the LLA community. Thank you so much, sir.
Thank you, everyone, and LLA and all the participants and all the viewers who are having their time to spend to listen to my session. Thank you so much.
Thank you so much, sir. It's a pleasure hosting you, and probably in some time in future also we will have pleasure of hosting you again.
Okay, thank you. Maybe sometime if I am fortunate to give something on code on whatever labor reform codes I've already hit.
That would be great, sir.
Something like that.
That would be great because that's the burning topic right now, and everyone is trying to understand these new codes. So I guess yes, that is a burning topic, and as soon as the rules etc. are notified, these should be again a separate big challenges in front of HRs and compliance personnels.
Okay.
Thank you so much, sir. Thank you so much.
Thank you so much. Thank you.
तो दोस्तों उम्मीद करता हूं आज का ये जो वेबिनार है आपको इंटरेस्टिंग लगा होगा, और आई नो इट इज थोड़ा सा कॉम्प्लेक्स है, लेकिन जो कॉम्प्लेक्स है तो कॉम्प्लेक्स है, अभी उसमें क्या कर सकते हैं। और हमारी तो यही कोशिश है, और सर ने भी अपनी तरफ से पूरा प्रयास किया, और हमारी भी यही कोशिश है कि आपको ज्यादा से ज्यादा उस नॉलेज के बारे में, उस प्रोसेस के बारे में, कंप्लायंसेस के बारे में पता चल सके। तो चलिए इसी तरह से एलएलए के किसी एक और एक्सक्लूसिव वेबिनार में मिलेंगे। अगले सैटरडे का हम लोग कोशिश कर रहे हैं वेबिनार के बारे में, और उसकी जो भी डिटेल्स है आपके साथ ग्रुप पर शेयर कर दी जाएगी। अगेन आई रिक्वेस्ट, अगर आप में से कुछ लोग वेबिनार देख रहे हैं और अभी तक हमारे मेंबरशिप ग्रुप का हिस्सा नहीं बने हैं, तो आप हमें मेल कर सकते हैं अपना कॉन्टैक्ट डिटेल्स, और हम आपको ग्रुप में भी ऐड कर देंगे। तो आज के एपिसोड में इतना ही। ऋषभ जैन